Hello. Hello, good morning, all my students. Welcome to our online class again. Okay, so we are again checking the course on the law on jurisdiction acts and contracts. Okay, so we have just finished the part on jurisdiction acts. Okay, so now we are coming to the part on contracts. Okay, for the part on contract, we are going to look at first the nature and a definition of a contract, okay? And we will also look at the classification of contracts, how contracts in this country in Thailand are classified, okay? And the important topic for this morning is the formation of contract, okay? But it will take quite a long time, okay, for this topic, okay, formation of contract. So this morning we will look at an offer, okay, what is going to be an offer for the purpose of the formation of a contract. As regards the acceptance and other topics, we will defer our discussion to next time, okay, and for you to look at, okay, all other important items, okay, to be covered by this part on contract as well. Okay, we will look at the nature of promises, okay? What is a promise? How is a promise, okay, different from some other things, okay? So that we will also cover this topic maybe the next week. And after next week, we will look at effects of a contract when a contract is formed between the party. What are going to be the effects of that contract, and when the contract operates, okay, each parties will have, of course, some obligations and some rights, okay. Two parties in the contract may have to perform obligations under the contract and will also have some rights, okay, under that contract. Let's suppose that if a contract comes to an end, okay, that how we will call a contract to come to an end, okay, so that is going to be the topic regarding the rescission of contract, or we might also use the term termination of contract, okay. How is a contract going to be terminated, okay? It doesn't mean that once the contract is formed, a contract can just, come to an end when at any time, okay. There must be some grounds for rescissions or termination of a contract, okay. So all this will be in our part on contracts, okay. We are going to begin with perhaps the nature and a definition of a contract, okay. When we talk about a contract, what is it, okay? What is the nature of a contract, and is there a definition of a contract, okay? So to put simply, a contract is what? A contract is, in fact, okay, if we look at, the general nature of a contract, we can say that a contract is indeed a bilateral or multilateral jurisdiction act. Remember, when we talk about, the jurisdiction acts, we can see that we can classify jurisdiction acts, okay, into, let's say, that unilateral jurisdiction acts and bilateral or multilateral jurisdiction acts, okay. Why do I say that a contract is a bilateral or multilateral jurisdiction act? Okay, the answer is that a contract, it is a jurisdiction act which is made by at least, okay, two parties. If there are two parties, then we can see that that contract is a bilateral jurisdiction act. But if there are more than two parties, then that contract may be what? Maybe a multilateral jurisdiction act, okay? So we can see that a contract is also a jurisdiction act, okay? That it is a bilateral or multilateral jurisdiction act, okay? And going to the general nature of a contract, when we say that a contract is indeed a bilateral or multilateral jurisdiction act, okay, which has, of course, at least two parties. If there are two parties, then that contract is a bilateral jurisdiction acts. If there are more than two parties, then that contract is a multilateral jurisdiction act. Okay. When we talk about the word parties, you must not. Okay. You must not understand that. You must not understand only that. The party is just one person. Sometimes, okay, when we use the word parties, okay, one party may consist of maybe, okay, more than one person. That is something possible. Okay, the one party may consist of even several persons. We are going to look at the example from this slide. Okay, I have the example number 1, number 2, and number 3 for you. If you look at the example number 1, okay, you will see that, okay, it is also a contract made by whom? It is a contract made by A and B. Let's suppose that A enters into a contract with B, and under this contract, okay, A agrees to sell his car to B. Okay, you can see that that a contract whereby one party agrees to sell a car to the other party. That is just a contract of sale. Okay, you can see that this contract of sale is made between A and B, indeed between two parties. The first party is A. It is example number 1 here. The first party is A. The second party is B. Right. You can see that in the first example, the party consists of one person. Okay. Each party consists of one person. Party 1 consists of A, and party 2 consists of B. But we can also see that in some cases, one party may consist of more than one person. One party may consist of two persons, or even more than two persons in some cases. Okay, look at the example number 2 here. Let's suppose that we have in this example number 2, we have the Riverside Hotel here. The Riverside Hotel Company Limited. Normally, if you just set up your hotel, normally you will set up a company. Okay, a company which runs a hotel business. So that this hotel is the Riverside Hotel, but in fact it is a company called the Riverside Hotel Company Limited. Okay, this hotel enters into a contract with Thammasat University and also Chulalongkorn University. Okay, the hotel makes a contract with these two universities in Thailand. Okay, these two universities, Thammasat University and Chulalongkorn University, just engages this Riverside Hotel to do what? To just host a conference, let's say that on the era of the administration of criminal justice under the disguised dictatorship regime in Thailand. Let's suppose that now we have a problem regarding regarding the due operation of the administration of justice, administration of criminal justice in this country. Okay, and the two universities, Chulalongkorn and Thammasat, just agree to just engage a hotel, the Riverside Hotel here, okay, to host the conference on this topic, on the topic of eroded administration of criminal justice in under the disguised dictatorship regime in Thailand. We can see that this is a high of work contract, or in Thai we call this one Jang Tham Khong. Okay, high of work. It is with a contract whereby one person just engages the other person. One person engages another person to do some work. So we call this contract as a high of work contract, a high of agreement. Okay, but in some country they do not use this term. Okay, because it is quite confusing when you say high of work. Normally, when you hire some property. Okay, when that we use the word high of work, sometimes it may just give rise to some confusion. So that in some countries they may use the word supply of service. Okay, a supply of service contract, something like that. Okay, whatever name we use. Okay, I mean it is a contract whereby the hotel here, the Riverside Hotel. Is engaged by Thammasat and Chulalongkorn to host a conference. Okay, we can see that under this contract, there are also two parties. Party number one is whom? Party number one is, who is party number one? Party number one is the Riverside Hotel, of course, the Riverside Hotel Company Limited. And party number two consists of two persons. Okay, party number two consists of Thammasat University and Chulalongkorn University. So in this example number two, we can see that when we use the word party, okay, it may consist of more than one person. Okay, so in this example number two, the second party here consists of two persons, i.e. Thammasat University and Chulalongkorn University. Okay, and if we just move on to the example number three, we can also see that we have a contract. Okay, a contract under which each party consists of, or the one of the party consists of more than one person. Okay, in this example number three, it is a contract made by first the Bangkok Bank and the Krung Thai Bank. Okay, these two banks, they get together in order to extend a loan. Okay, the two banks just jointly extend a loan to, let's say that to Nanakorn Cafe Company Limited. We have also this company, okay, called Nanakorn Cafe Company Limited. This company, Nanakorn Cafe, is in need of, a loan. So this company, the Nanakorn Cafe Company Limited, just makes the loan agreement with these two commercial banks. We can see that this is just what? This contract is called a loan agreement. Okay, and under this contract, we have again two parties. The first party consists of two persons. The first party is the lender. We can see that the lenders consist of two banks, Bangkok Bank and the Krung Thai Bank. Okay, and the second party consists of only one person, i.e. Nanakorn Cafe Company Limited. Okay, so from these three examples, we can see that sometimes when we have a contract, okay, when we have a contract, it does not mean that a party to that contract consists of only one person. Okay, it is possible that one party in any particular contract may consist of more than one person. Okay, so please do not be mistaken that the word party consists of just one person. It is very normal that when we talk about parties to the contract, okay, that each party sometimes may consist of more than one person. Okay, that is possible. Okay, now when we have look at the general nature of a contract, let's have a look at a definition of a contract. Okay, in all countries, the laws in all countries use the word contract. Okay, so is there any definition of a contract in the law in this country, in Thailand? Of course, you have to think of the civil and commercial code of Thailand. Okay, so in the civil and commercial code, there is no definition of a contract. Okay, no definition provided by the CCC, no definition provided by the civil and commercial code or CCC. Okay, but despite no definition, we can, in theory, we can define a contract as what? As a bilateral or multilateral jurisdiction act. Okay, and it is constituted by what? It is constituted by the meeting of the minds. Okay, the meeting of the minds here, the meeting of the minds, it is in that it is a meeting between two things. It is the meeting between first an offer and secondly an acceptance. One person makes an offer and the other one makes an acceptance. One person makes an offer and the other party just accepts that offer. And the acceptance must match the offer completely. So when we have, the meeting of the minds, in the sense of in the sense of, the agreement between what? The agreement between an offer and an acceptance, then we have a contract. So even we do not have any, exact definition of a contract in the civil and commercial code, but we can just perceive a contract as a product of the meeting of the minds, a product of the meeting of the minds, the meeting between an offer and an acceptance. One person makes an offer and the other one makes an acceptance of that offer. So if we have, two persons like this, that means that the two persons need to think of the same thing. The two persons need to just arrive at the same thing, okay? One person makes an offer and the other one makes an acceptance, so that there is the meeting of the minds, or if you prefer a Latin word, if you prefer a Latin expression, you may use the word consensus ad idem, okay? So consensus ad idem, it is the meeting of the minds in the sense of the meeting between an offer and an acceptance. We are going to go through the details of this later, in due course. Now, before going to the essence of the meeting of the minds, before going to explore, an offer and an acceptance, we are going to first, to look at the classification of contracts. We can classify contracts by reference to many things, We can also classify contracts by name. If we classify contracts by name, by reference to their names, we can have specific contracts and nameless contracts, Specific contracts, or in Thai we call this one เอกเทศสัญญา and nameless contracts, or สัญญาที่ไม่มีชื่อ we will look at this later. If we classify contracts by reference to remuneration, we can have remunerative contracts and non-remunerative contracts. If we classify contracts by reference to reciprocal obligations, we can have reciprocal contracts, สัญญาต่างตอบแทน and non-reciprocal contracts, or สัญญาไม่ต่างตอบแทน, Now we're coming to the first classification. Classifications by reference to names. Do we give specific names, for specific contracts, If we just classify contracts by name, we can have two groups. The first group is specific contracts, or in Thai เอกเทศสัญญา and the second one is nameless contracts, or สัญญาไม่มีชื่อ Now back to the first group, Specific contracts or เอกเทศสัญญา What are they? Specific contracts are contracts which are in common use. So when they are in common use, then our civil and commercial code does two things. The first thing is to give those contracts specific names. We don't need to, give them specific names to those contracts simply because the law does give specific names to those contracts simply because they are in common use, so that the law, the civil and commercial code gives those contracts specific names. And the second thing, which is done by the civil and commercial code with regard to specific contract, is to prescribe the rules, for those contracts. If we make the contract, let's say that if A and B want to make, one of specific contracts, let's say that A agree to sell a car to B. This is a contract of sale, simply because this contract of sale is in common use, so that the civil and commercial code just give a specific name for this contract. So if you look at, if you look at book 3 of the civil and commercial code, you can see that book 3 of the civil and commercial code of Thailand just lists, certain specific contracts, one of which is a contract of sale. So when A agrees to sell his car to B, this is a contract of sale, which is a specific contract in Book 3 of the Civil and Commercial Code, so that party A and party B do not need to give a specific name to this contract simply because the CCC already gives a specific name to this contract, calling this contract as a contract of sale, and the CCC on sale prescribes principles for this contract. A and B do not need to make specific agreement with respect to obligations or rights. If A and B do not reach specific agreements on obligations and rights, this means that A and B are bound by the principles as established by Book 3 of the Civil and Commercial Code. If A and B do not agree on obligations and rights between them, then everything will be governed by the rules in Book 3 of the Civil and Commercial Code. So that if you look at provisions in Book 3 regarding the contract of sale, you can see that the Civil and Commercial Code just prescribe some obligations and rights for the parties to a contract of sale. Of course, even though the law prescribes even though the law prescribes specific rules for a contract of sale, as a party to this contract, A and B may resort to the freedom of contract principle or the party autonomy principle to establish between themselves, the specific rights and obligations. So if the law says something, you have to be mindful that even though the law prescribes some rules, the parties have freedom of contract or party autonomy to establish their own rules, so that that the rules established by the parties are the droit de partie, or the law of the parties, which overrides the rules of law established by the Civil and Commercial Code. But in the absence of the parties' agreement, then the rights and obligations of the parties will have to be in accordance with the rules prescribed in the CCC. Again, we are now talking about what? We are now talking about specific contracts or 애기태선야. 애기태선야. There are contracts which are in common use, so that the CCC first gives those contracts specific names, and secondly, provides for the rules of law applicable to those contracts. We can have examples of specific contracts or 애기태선야, right? For example, a contract of sale and exchange, a gift, a hire of property, or you can call this one a lease, or a hire of work contract, or the supply of service contract. So these are examples of specific contracts. Now, even though Book 3 of the Code just provides for certain specific contracts, it does not mean, however, that parties cannot enter into other contracts beyond the list in Book 3 of the Code. Book 3 of the Code just contains a list of specific contracts, but in addition to the contracts which are included in Book 3 of the Code, parties may also make all other contracts. Parties may, of course, the party enjoy the what? Freedom of contract or the party autonomy. They can just make any contract they would like to do. Even though those contracts are not listed in Book 3 of the Code. Any party may just make any contract according to the freedom contract principle. So that contract, even though it is not a specific contract, it is also a binding contract. It has no specific name, so that we can call this one the nameless contract สัญญาไม่มีชื่อ okay in Thai right I'm going to give you one example here. Let's suppose that we have a contract between A and B. A is a lawyer. Let's suppose that the B, he is accused of having done something wrong, and B cannot just afford a lawyer. Okay, B, let's say that B is rather poor, and B is in need of a lawyer, but when B cannot just afford a lawyer, so that A just tries to help B. A just agree to do what? A is a lawyer. A is a practicing lawyer, so A agrees to help B. A agrees to just represent B in courts free of charge. Okay, A does not charge any money from B. A agrees to be B's lawyer. A will just represent B in courts until the case becomes final. In this case, we have a contract between A and B. Under this contract, A agrees to be a lawyer for B. A agrees to represent B in court free of charge. We can see that this is not a hire work. Okay, this is not hire work in Book 3 of the CCC, because if it is hire work in Book 3 of the Civil and Commercial Code, then B will have to pay A. But in this case, A agreed to represent B free of charge. That means that B does not need to pay anything to A. A agreed to do some work for B without any remuneration from B. In this case, it is not a hire work, because the law says that in hire work, then in hire work, then the person who engages another one, okay, to do the work will have to pay for the work. But in this contract, okay, A just agreed to do some work for B without B having to pay A anything at all, so that it is not a hire work. But it is also a contract. It has no specific name. It is a nameless contract. It is binding upon A and B, because A and B just enters into this contract voluntarily. It is one juristic act, which is binding upon the parties. Okay, so that in this case, A and B has made this contract. In addition to the contracts which are listed in Book 3 of the Code, this contract does not fall within Book 3 of the Code, but it is still a contract between the parties, Party A and Party B. It is a nameless contract which is binding upon A and B nonetheless. Okay, so if you are interested in making any contract which is not in Book 3 of the Code, you can do so. You can just make use of your freedom contract or your party autonomy to enter into an agreement with anyone. Okay, even though your agreement is not one of the specific contracts in Book 3 of the Code. Again, now we classify contracts by reference to the names. Okay, if we classify contracts by reference to names, we have specific contracts and nameless contracts. Now we are going to look at the classification of contracts by reference to remuneration. Okay, if we classify contracts by reference to remuneration, okay, we will have also we will have also the remunerative contracts and non-remunerative contract. But before coming to this part, I'm going to get back to the examples of nameless contract. Okay, just now when we talk about nameless contract, we have come to the conclusion that a nameless contract, it is a contract which does not fall within Book 3 of the Civil and Commercial Code, but the parties do make that contract, okay, by resorting to the freedom contract or the party autonomy. We have some examples. Okay, indeed, this example is drawn from the Supreme Court case. In the example, let's suppose that, okay, that we have A, B, and C here. Okay, A acts as a guarantor, okay, for B's obligation. B has some obligation. Let's say that B has borrowed money from somebody. When B, has to perform some obligation, okay. If somebody acts as a guarantor, we can use the word guarantor or a surety, okay. These two words, surety and guarantor, they are interchangeably used, okay. If A acts as a guarantor for B's performance, that means that if B does not perform the obligation, then A, the guarantor, will have to perform the obligations on B's, okay, that A will, as the guarantor, will have to perform the obligations, okay, in place of B, right? So in this case, of course, as a guarantor, A will have to be, A will have to just, be bound by the guarantee agreement. Okay, we have a guarantee agreement here. Under the guarantee agreement, A acts as a guarantor in the event where B does not perform B's obligation, then A will have to perform the obligations, okay, in place of B. Right. Now, say, C comes to the scene. C has entered into an agreement with whom? With Z. We have now an agreement between A and C. Okay, under the agreement between A and C, C agrees to do what? Of course, when A as a guarantor, A will have to, A will have to perform the obligations, okay, in place of B if B is in default. So C makes promise to A that, well, A, don't worry. I know that you are the guarantor and you may suffer some loss, okay? If you suffer any loss, then I am C here, okay? I am going to just indemnify you for any loss which arises from your guarantee, okay? I know that you act as a guarantor. This is what is said by C to A. C promises to do what? C promises to indemnify A if A suffers any loss as a result of a guarantee, okay? So we have an agreement between C and A like this. Under the agreement between A and C, C agrees to indemnify A for any loss arising from the guarantee. Okay, so in this case, the contract between A and C here does not fall in Book 3 of the Code. Even though it does not fall in Book 3 of the Code, it is also a binding contract between A and C. This is, according to the Supreme Court, this is a nameless contract. Okay, a nameless contract binding upon A and C. So, if A suffers any loss as a result of the guarantee, then C is bound to indemnify A for this loss. Right. Okay, this is an example drawn from the Supreme Court case. Now, we're coming to one more case which is drawn from the Supreme Court, okay? I think that this case seems to be even more familiar to you, okay? It is concerned with the use of a credit card. I'm sure that many of you here also have credit cards. Some of you here may have even more than one credit card. Okay, so when you have a credit card, this is very convenient because you can just make the purchases of goods or services, okay, without having to pay cash. In this case, of course, you may have a credit card issued by, let's say, that a commercial bank or a credit card issuer. So that a bank, let's say that this bank, Citibank, issues a credit card to you. Okay, so you have a contract between whom when Citibanks issue a credit card to, let's say, to me. Okay, I have the Citibank credit card here. So I have a contract with the bank. Under this contract, I can use this card to pay for goods or services, okay, without having to pay cash. And then, Citibank agreed to just pay merchants, okay, for the prices of goods or services which I purchase from the merchant, okay. Put simply, Citibank will have to advance money for me first. And then Citibank will just bill me later. Okay? So after Citibank makes payment to merchants, then Citibank will have to just bill me. Okay, and then what is going to be gained by Citibank? Of course, Citibank will gain what? Citibank or the credit card issuer will gain what? Will gain the annual fees. Okay, sometimes the credit card issuer just collects or charge annual fees, and the credit card issuer also charges the fee from the merchants as well. Okay, so this is the agreement between a credit card user and the credit card issuer. So a contract between the credit card issuer and the credit card user, it is what kind of contract? According to the Supreme Court, this is a nameless contract. It is not a loan of money. When the bank agree to advance money for the user, for the credit card user, and will bill the credit card user later, that is not the extension of any loan of money. Okay, it is just a nameless contract whereby the bank, the credit card issuer agree to advance money for the credit card user first, and then will just bill the credit card user later. Okay, and the credit card issuer will charge an annual fee, okay, on the credit card user. This is a nameless contract. So the Supreme Court held that this kind of contract is a nameless contract which is binding between the parties as well. Okay, so this has been a very good example of nameless contracts. Okay, now we're moving on to classifications of contract by reference to remuneration. Remember, if we classify contracts by reference to remuneration, we will have two groups. The first group is the remunerative contracts, and the second one is the non-remunerative contracts. Okay, now we are going to have a look at this classification. Okay, classification between the remunerative contracts and non-remunerative contract. Remunerative contract and non-remunerative contract. Remunerative contracts, in Thai we call this one สัญญาซึ่งมีค่าตอบแทน. As the name suggests, remunerative contract, it is a contract whereby each party is obligated to do what? To provide remuneration for each other. Party A and Party B agrees to provide some remuneration for the other party. Party A also provide remuneration to Party B. Similarly, Party B also provide remuneration to Party A. Right. Two parties, each party agrees to provide remuneration for the other party. Okay, have a look at a contract of sale. Okay, if we have a contract of sale, then we have a seller and a buyer. A seller will have to do what? A seller will have to provide remuneration to the buyer in the form of what? In the form of delivering property to the buyer, and the buyer will have to provide remuneration for the seller in the form of paying money, okay, paying the price. So the seller will have to deliver the property to the buyer, and the buyer will have to pay the price to the seller. So two parties in a contract of sale, each party provides remuneration for the other one. Okay? Or take a look at an exchange. สัญญาแลกเปลี่ยน Okay? I have this computer. I just want to make an exchange with you. Let's say that you have the motorcycle. I agree to just let you have my computer, and you agree to let me have your motorcycle. In this case, an exchange, it is also a remunerative contract simply because two parties provide remuneration for each other. Okay, I provide remuneration to you by letting you have my computer, and you provide remuneration to me by letting me have your motorcycle. Okay, but if we look at a non-remunerative contract, okay, a non-remunerative contract, it is a contract whereby one party derives just a contractual benefit without having to give any remuneration to the other party. One party just derives some benefit without having to give any remuneration to the other party. Take a look at a loan for use. Let's say that you do not have any computer for your online your online classroom. Okay, let's suppose that I have many computers. I have this computer and I also have this computer. I say, well, don't worry, I'm going to lend you this computer. This is a loan for use. Or in Thai, ยืมใช้คงรูป I lend you this computer, and when you finish using it, you have to return it to me. In this case, you can see that I'm the lender, you are the borrower, okay? As a borrower, you do not need to give me any remuneration, okay? Because in this case, I allow you to use this computer free of charge. You don't need to pay me at all, so that you derive a contractual benefit without having to give me any remuneration, so that this contract, it is a non-remunerative contract. Okay, this is something quite clear, okay? Now, we are going to classify contracts by reference to reciprocity, okay? By reference to reciprocity. In this case, we have the so-called a reciprocal contract and a non-reciprocal contract. What is it when we talk about a reciprocal contract? Okay, I hope that you know this word, okay? Reciprocal. Okay, we classify contracts by reference to reciprocity, okay? A reciprocal contract, it is a contract whereby each party will have to perform some obligations for the other. Party A and party B, let's say A and B, they have entered into a contract, and this contract, A will have to perform some obligation for B, and B will also have to perform some obligations for A. In this case, when two parties perform obligations, okay, for the other, this contract, it is a reciprocal contract or สัญญาต่างตอบแทน right? A contract of sale, it is also a leading example here. If we look at a contract of sale, again, we have a seller and a buyer. The seller will have to do what? The seller is required to deliver the goods or the property to the buyer, and the buyer will have to pay the price. We can see that in a contract of sale, both parties perform some obligations for each other. Okay? But if we have a contract whereby only one party will have to perform some obligation without the other party having to perform any obligation either, okay? That is a non-reciprocal contract. Only one person has to perform the obligation for the other party, but that other party does not need to perform any obligation for the first party, okay? A very obvious example is the gift. Let's suppose that, that I promised to give you my house, right? When I promise to transfer the ownership of my house to you, in this case, you don't need to perform any obligation for me. You will receive my house, okay, without having to perform any obligations in my favor. So this contract is a non-reciprocal contract. สัญญาไม่ต่างตอบแทน Okay, so I hope that you are clear about the classifications of contracts. If we go back to classifications of contract, remember we have three ways of classifications. We can classify contracts by name, so that we have specific contracts and nameless contracts. We may also classify contracts by reference to remuneration. In this case, we will have remunerative contracts and non-remunerative contracts. And if we classify contracts by reciprocity, we will have reciprocal contracts and non-reciprocal contracts. Okay. Now we are coming to an important part of the lecture. Okay. After we have looked at the nature of a contract, a definition of a contract, and also classifications of contracts, we are looking at a very important topic here: formation of a contract. Okay, so I think that now my cat is in this room and she is walking around. Okay, so if she cries, okay, in order to request me to let her out, then I beg your pardon. Okay, so that I have to just stop a while for letting my cat out of this room. Okay, but now she is okay. She's walking around this room. All right. Now, formation of a contract. We have seen that a contract is a product of what? A product of, again, the meeting of the minds, in the sense that it is a meeting between what? Between an offer and an acceptance. One person makes an offer and the other one makes an acceptance. So that when an offer and an acceptance just meets, we will have the meeting of the minds, and that is a contract. So a contract, it is the product of what? A product of consensus between two parties. One party makes an offer and the other one makes an acceptance. The acceptance which match, okay? The acceptance which matches the offer completely, okay? So if one person makes an offer of something and the other one just accepts that offer without any change, when an acceptance just matches the offer completely, so we will have the meeting of the minds, so that we will have a contract. So put simply, a contract, it is a product of the meeting of the minds, a product of one party making an offer and the other one accepting that offer. Okay, we are going to go to the details of this in the due course. Now, please just allow me to let my cat out. Okay? Okay, come, cat. Okay. Okay, very good. Welcome back. Okay, I have now released the cat out of this room, okay, so that she will not disturb me in the course of my teaching. Let me just drink water first. It is now near the Songkran festival in Thailand, okay, so that everybody try to just wear something colorful in order to celebrate the Songkran festival, okay. We are going to have the Songkran festival next week. In fact, the long vacation, so I hope that you will also be ready for the online classroom as well. Okay, the term is going to end in fact a month's time, and of course, even though we have a long vacation during the Songkran festival, I do not want to just cancel my classes on during the Songkran festival, because you can just you can just maintain the online classrooms, okay, without coming to the university. So that I don't think that we need to just cancel classes during the Songkran festival. That's why I try to just hold my online classrooms as usual. I'm going to just record my teaching, okay, so that you can, even during your Songkran festival, you can just view my video clips, okay, on YouTube, okay, at your convenience. Now back to the formation of a contract. Remember, a contract is formed by the meeting of the minds, in the sense that one person makes an offer and the other one just accepts this offer. Okay, so a contract, it is that it is a product of consensus. Okay, again, if you prefer a Latin term for the meeting of the minds, you may just use the term consensus at the item, okay? So, when A, let's suppose that this is A and this is B, when A makes an offer to B, B needs to accept A offer, and B's acceptance needs to match the offer completely. There must not be any change, okay? B's acceptance must not change A's offer in any way, so that when we have an acceptance which matches the offer completely, that is the unqualified acceptance. Okay, the acceptance which does not change the offer in any way. But if you have accepted the offer, if you accept the offer with some change, that is a qualified acceptance, and that is not, that is not going to just lead to any formation of a contract, because if A makes an offer and B accepts this offer with some modification, okay, that acceptance does not match the offer completely, so that in this case we do not yet have the meeting of the minds, simply because B's acceptance differs from A's offer. In that case, there is no contract. So in order for a contract to be formed, the acceptance must match the offer completely without any modification, okay? We need to have an unqualified acceptance in order for a contract to be formed. Okay, this is something to be made clear. But before we have a contract in practice, okay, before we have a contract in the end, in many cases, okay, parties 1 and party 2, or party A and party B may they may enter into many rounds of negotiations, so that they may be negotiations, okay, before the formation of a contract in the end, okay. Now, but this is something which is beyond the syllabus, okay. We need to answer raise a question as to whether or not, before a contract is formed, let's suppose that A and B enter into negotiations. Okay, in the process of negotiations, does party A or party B have some obligations? Let's suppose that when party A and party B have entered into negotiations, let's suppose that they have talked about whether or not to enter into the contract. They have, that they have embarked on a lot of negotiations, many rounds of negotiations, and in the end, A does not want to enter into this contract. Will A be liable for B for not making a contract with B in the end? The answer is no. Because normally in this country, in Thailand, okay, before a contract is formed, in the pre-contractual stage, no party will have any obligations, okay? So that A and B both enjoy the freedom of contract. When I say that A and B enjoys freedom contract, that means that A and B can also choose whether to enter into the contract. And if A and B choose to enter into the contract, A and B may also set the terms of their contract freely. If A decides not to make a contract with B, that is when the exercise of A's freedom contract. When A decides not to enter into a contract with B, A will not be liable. So before a contract is formed, normally each party is not under any obligation, okay? This is when if we consider this is the position in this country, but in certain countries, okay, in certain countries, even at the pre-contractual stage, parties may have some obligations. Let's have a look at the laws in England. Okay, English contract laws have some principles by which parties may be also liable for the other party. Okay, in the event of not making a contract in the end. Let's suppose that but this is something beyond our syllabus. Okay. In the English law, they also have a doctrine called a collateral contract doctrine, okay, by which, okay, if A makes any statement to B, even before this contract is formed, in the end, if a person just makes any statement to the other one or another one, in order to induce the other one to enter into a contract. So the statement made by that party, let's say the statement made by A to B before the final contract, A and B just enter into negotiations, and A, during the negotiations, A made a statement to B in order to induce B to enter into this contract. The statements made by A may also be binding, so A is possibly bound by a promise given, okay, before the formation of a contract. Even though the contract has not yet been formed, a statement made by A to B can also be binding on A. Okay, so that in some cases, if A does want to depart from his promise, which is given in the stage of negotiation, A may also be liable to B. What I'm saying now is that in Thailand, normally no party will be liable to the other one in the process of negotiation, okay? But in some countries, even in the process of negotiation, there will be some obligations. If let's suppose that A have negotiated with B, and the negotiation has been proceeded to the extent that it has given B reliance that there will be a contract in the end. And if A just breaks off negotiations without any reason, breaking off negotiations, okay, in bad faith may also make a liable to B. The liability before a contract is formed like this, it is called a kunpat in contrahendo, okay, but it is not the subject matter, okay, included in the LLB curriculum, okay. If you are interested in this kind of thing, then you are going to proceed to your graduate study, okay. We are going to discuss all of this. Okay, we are going to discuss this kind of matters in your LLM degree, okay, the program. If you are interested, okay, when you leave this law school, okay, when you graduate with your LLB degree, then you can proceed to the LLM degree program. Right now, now we have seen that a contract is a product between what? Again, the contract is a product of the meeting of the minds in the sense of the meeting between an offer and an acceptance. One person makes an offer and the other one just accept that offer without any modification, okay? When A makes an offer and B accepts an offer with no modification, we will have a contract, which is of course a meeting of the minds. Two minds, A's minds and B's minds. So we call this one the meeting of the minds. Not the meeting of the mind, the meeting of the minds. A's minds and B's mind. Okay, so we are going to have a break for a few minutes, and then we are coming to have a look at the nature of an offer. Of course, there will be an offer and an acceptance for the purpose of the formation of a contract, okay? We will look at the nature of an offer first. And after we discuss an offer, we are going to move on and acceptance. Okay, so now let's have a break for about 5 to 10 minutes, okay? Then we are going to resume the class very soon. Okay, see you very soon.